Hello, this is Rachel Erdman, Podcasting Committee of the Intellectual Property Section of the State Bar of Georgia. Welcome to another one of our podcasts. This focuses on the presumption of irreparable harm in requests for injunctions after eBay. This was originally recorded at the State Bar of Georgia Conference Center on November 28, 2012.
So let's get started. My name is David Lilenfeld. I'm happy to be the moderator today. I'm chair of the litigation committee of the bar, State Bar, the IP section of the bar. And welcome, thank you for being here. We have a good turnout. I was asked to remind everybody, the IP section also has an event December 5 at noon. I think it'll be in this room. It'll be the deputy director from the trademark office will be here talking about kind of current ongoing affairs of the trademark office. So that event is next week. You can register at georgiabar.org. So my name is David Lilenfeld. I have an intellectual property boutique law firm here in Buckhead called Lilenfeld PC. Our superstar associate is back there, Morgan. Thank you for being here. Thank you for your help. As we all know, injunctions are critical in IP cases. Most of the time, money damages aren't going to do it for our clients. Damages are hard to prove, so injunctions are kind of the key. I get the comments all the time from clients like, when can you make this stop? How come you haven't made this stop? Probably most common is, how much is it going to cost me for you to make this stop? So we're all familiar with that. And then really here to talk about eBay and MercExchange, a Supreme Court case from 2006, and not really just that case, but what's occurred after it, and whether that case has had as big of an impact on the injunction landscape as we had expected it to. And that's why we assembled this great panel. But just briefly, because I know it's been a while since the case came out, I was going to give a very short facts on the case. MercExchange owned a suite of patents, sort of the centerpiece of which was a patent which was proven to cover eBay's Buy It Now feature. So that was a site, if you're not familiar with it, a feature on eBay where you didn't have to wait for the auction to expire. The seller could have the option of putting the object up for sale at a definite price, and you could just sign on to eBay and buy it without having to wait for the auction to expire. It's been handy in my house because it's not easy to explain to a 5-year-old why he'll have to wait 7 days to figure out if he's getting his new CSX engine. So I've used that, and that's been helpful. Actually, interesting stat that 30% only, I thought it was low, only 30% of all the products on eBay are sold through Buy It Now. So that means 70% of the auctions are actually timed auctions that people patiently wait on and bid on. So anyway, MercExchange and eBay got into negotiations for eBay to purchase the patents. They never came to terms, and after negotiations broke down, MercExchange filed a patent infringement lawsuit in the district court in Virginia. And after a trial, they obtained a successful verdict. They moved the district court for a permanent injunction. The district court denied the request for the injunction. MercExchange appealed that to the Federal Circuit. The Federal Circuit reversed the district court and included in its opinion this quote: the general rule is that courts will issue permanent injunctions against patent infringement absent exceptional circumstances. That the case was appealed to the Supreme Court of the United States, which, as we all know, overturned the Federal Circuit and kind of set a new precedent for how injunctions are to be handled in patent cases and really in all IP cases. Just a few stats before I introduce the speakers. We found some interesting stats on injunctions. Some of it's a little bit dated, unfortunately. We couldn't get absolutely current. This is from a website called patstats.org. According to that website, between 2005 and 2009, there were 182 rulings on requests for preliminary injunctions in patent cases. And just about 50-50 split on grant versus denied. So out of 192 rulings, the patent owner was able to get a preliminary injunction in 92 cases, which was 50.5% of the time. That same website had stats on permanent injunctions, and the rate, understandably, was a lot higher. Basically, out of 213 requests for permanent injunctions, the permanent injunction was granted 75% of the time. Interestingly, out of those 213 cases, 4 of them were from Georgia, and permanent injunctions were granted in all 4. There was 3 out of the Northern District, and 1 was actually Frank's case out of the Middle District of Georgia. So in Georgia, there are 4-0 permanent injunctions. All right, our great speakers. First, we have Ann Fort, good friend and excellent lawyer. Ann has obtained her undergraduate degree from Georgetown and a law degree from University of Virginia. She is a partner in Sutherland's intellectual property practice group. She's a seasoned litigator, has handled disputes covering a variety of subject matters, including software, web-based businesses, computer chips, television program guides, just to name a few. We've asked Ann to speak. She's on this particular topic because she's litigated injunctions and IP cases since eBay came along, including successfully defending the Federal Reserve Bank of Atlanta against a copyright infringement claim in which the plaintiff sought a TRO, and ultimately Ann got that TRO denied. That was a case in front of Steve Jones in the Northern District of Georgia. Ron Coleman. Ron is sort of the engine behind today's program. He received his undergraduate and law degrees from Duke University as a partner at Parker Hudson Rainer Dobbs. Ron has written extensively about this issue of preliminary injunctions post-eBay. He is included, I think you all should have a copy of it. He wrote a very thorough, along with some help from smart folks at his firm, a very thorough 12-page article that was published in the American Bar's Franchise Law Journal. It should be a resource for everybody. It was published recently, September, I think, in the Franchise Law Journal. And finally, we got Frank Smith. Frank's received his undergraduate degree from Davidson College, his law degree from Stanford. He is a partner in Alston Bird's intellectual property litigation group. He concentrates on patent and copyright disputes. We asked Frank to speak. He was involved earlier this year. He was able to obtain a preliminary injunction on behalf of a client who owned a patent relating to flea and tick medicine for pets. That was a injunction Frank obtained for his client out of the Middle District of Georgia in front of Judge Lamb. So at this point, I'm going to turn over to the panel, and thank you again for your effort.
Thank you.
Well, thanks everybody for coming. I'm Ron Coleman, and hopefully we'll make it worth your while for spending your lunch with us. I would just want to observe, first off, that this is probably the first time I've ever spoken where people voluntarily took the first 2 rows in the thing. I'm not sure what that means, but I hope that means we've got a great group who are interested in asking questions and not just listening to us ramble on. So feel free, although we're going to have some time for questions at the end. We would all 3 strongly prefer that you interrupt, raise your hand, or at least be awake in case we call on you as we go along. Our overview of our program today, I'm going to give a brief overview of the issue and of the eBay decision, as David mentioned, just to set the scene. But the meat of our program is going to be talking about 3 particular contexts. One is how eBay has been applied In patent injunction cases, obviously eBay was a patent case. The law is fairly well settled, but as we all know, it's the application and the facts of particular cases that make what we do interesting. And so Ann is going to cover that with some interesting case examples. Frank is going to talk about some practical issues in obtaining and enforcing IP injunctions based on some of his experience. And again, I think that's going to be very interesting. And then finally, I'm going to come back and talk a little bit about the application of eBay in other intellectual property contexts, particularly trademark infringement, because surprisingly things are still a little bit up in the air in that area. Just briefly to set the scene, pre-eBay, as David said, in patent cases, the Federal Circuit applied a general rule that permanent injunctions, injunctive relief would be granted upon proof of infringement absent exceptional circumstances. And that was generally regarded as a presumption of entitlement to injunctive relief upon proof of infringement.
I think we decided we will probably away your slide.
The waters have parted. So patent cases, similarly in trademark cases, they're all the way back to early cases in the 11th Circuit, Burger King versus Mason, and other cases, the venerable presumption of irreparable harm upon showing of trademark infringement. Courts generally recited things like owner's loss of control of the mark and damage to reputation. And those of us who pursued trademark injunctions in the pre-eBay era didn't have to use much of our page limit in a brief on the irreparable harm factor. We could have a couple of sentences and cite to those cases and move on. eBay comes along and throws, if not changes all that, at least throws it up in the air. And I won't go back over the facts of eBay that David said, but the procedural posture is that the infringement was proven, damages were awarded, injunctive relief was denied in the trial court. Federal Circuit reversed the denial of injunctive relief and applied the general rule that we talked about earlier. It goes to the Supreme Court, and the Supreme Court reverses the Federal Circuit and basically says injunctive relief is injunctive relief. We apply the traditional four-part test for injunctive relief in patent cases, just like any other case. And interestingly, I'm not that much of a Supreme Court opinion geek, but the concurring opinions in that case are actually pretty interesting to read, because Justice Roberts wrote an opinion that was very historical and traced the history of injunctive relief, and basically concluded that although we're changing the Federal Circuit's rule, injunctions should still be granted more often than not in patent cases. And Justice Kennedy kind of gave a nod to changing technology and the changing legal landscape of non-practicing entities bringing patent infringement lawsuits, and said this test is important to address the current landscape of patent litigation, and made particular reference to entities that didn't make a product but sued for patent infringement, and courts have latched on to that, and I think that's a significant observation in the opinion. So, to bring us up to where we're going to get off on our discussion today, 6 years later, what's the impact of eBay? And actually, interestingly to me anyway, it's pretty inconsistent. And over the last 6 years, there have been a number of issues that have come up in lower courts. First, people said, well, that applies to permanent injunctions, but it doesn't apply to preliminary injunctions. And most courts have decided, no, it applies to all requests for injunctive relief. In patent cases, the pendulum swung back and forth, and it was, some courts were much stricter on the irreparable harm standard. Others would focus on the fundamental nature of the right to exclude for a patent holder. And Ann will have some very interesting discussion in a minute about some of the economic analysis and the competitive market analysis and demand drivers for the product and things like that. Lanham Act cases, which I'll come back to at the end, are actually, surprisingly to me anyway, very inconsistent in this area. A majority of the circuit courts have not abandoned or not ruled that the presumption of irreparable harm does not apply in trademark infringement cases. They basically say eBay applies, but our trademark case is different based on the different nature of the right protected, and that's something we'll talk about a little bit when we get to that one. So that's the overview. I want to emphasize again that we really want people to ask questions, make observations, challenge us, just don't throw things, and hope we'll have an interactive presentation. So Ann, I'll turn it over.
Thanks, Ron.
Hello, this is Rachel Erdman, Podcasting Committee of the Intellectual Property Section of the State Bar of Georgia. This is part 2 of our podcast, Presumption of Irreparable Harm and Request for Injunctions After eBay, as presented by N.G. Fort from Sutherland. This was originally recorded at the State Bar of Georgia Conference Center on November 28, 2012.
Hi, everybody. Thanks for coming. So, what I'm going to talk about today is a couple of relatively new cases from the Federal Circuit that are discussing the irreparable harm prong in light of eBay and trying to walk the path that maintains fealty to the eBay instruction from the Supreme Court that says, "Thou shalt not apply a presumption," while at the same time recognizing the importance of the nature of the patent right, which is the right to exclude. So there's the case from 2011, the Bosch versus Pylon case that some of you are probably familiar with. That is a case involving windshield wiper blades. And in the Federal Circuit's consideration of that case, the court reversed the trial court for its refusal to enter a permanent injunction at the conclusion of the trial on liability issues. And the Federal Circuit took advantage of this opportunity to announce, if there were any doubt about this, yes, the presumption of irreparable harm is confirmed dead. But there's always a but. It does not follow that courts should ignore the fundamental nature of patents as property rights granting the owner the right to exclude. The right to exclude is not sufficient alone to justify the injunction, but it ought not be ignored in the analysis either. So where does that bring us? Well, let's talk a little bit about the factors that the Federal Circuit considered important in the Bosch versus Pylon case. Now, I like to call this the "we lost Walmart" case, because bottom line, that is the evidence that the plaintiff kept pointing to as the source of the irreparable harm they suffered as a result of the infringement that could not be compensated purely by money damages. And I imagine at least some of you have had the experience of a client coming to you and saying those exact words: "We lost Walmart. Surely there's someone we can blame for this, and we can get them out of our way and we can get back to Walmart." Because everybody who sells anything wants to be in Walmart. So what were the factors that the Federal Circuit said compelled an injunction in this case? Well, the first thing that was pointed to was the existence of direct competition between the patentee and the infringer in all of the market segments. And that direct competition by the infringer led to 3 injuries: irreversible price erosion, lost customers, Walmart, and lost access access to customers. The lost access to customers argument was supported by testimony by a marketing executive who said, if we're not in Walmart, we can't get in Kmart or any of the other mass merchandisers. And the lost market share. So lost market share based significantly on loss of Walmart, because Walmart was the elephant in the living room controlling so much of the market for these windshield wiper blades. The other prong that was very significant to the Federal Circuit was proof that the infringer was likely unable to satisfy a money judgment should one be entered. Now, at this point, I just want to point out that some of you may be following this case in connection with the recent en banc grant by the Federal Circuit. The en banc argument is going to be focusing on the decision by the trial court to bifurcate some of the issues for trial. That is a separate appeal from the appeal of the injunction issues. So there's been no vacator of, or vacatur, or however you want to say that, of the injunction opinion. So the injunction opinion is still good law, can be relied upon by anybody for anything. But we are going to want to be watching how the bifurcation issues are addressed afterwards. So let's talk a little bit about this multi-competitor market. You know, the typical situation where you have the strongest case for your injunction is a market in which there are only two competitors. You, the patent owner, and the infringer who is then proven to be an infringer. Now, in this case, there was a multi-competitor market. And Judge Robinson in the District of Delaware decided that that meant there could never be an injunction. Federal Circuit said that's wrong. There can be circumstances when an injunction is appropriate if the infringer is demonstrated to be the cause of the harm. So in this case, Bosch had been enforcing its patent rights against other infringers and had gotten other infringement to stop. So that meant that there was a causal link between the continuing harm and this one infringer, Pylon. We lost Walmart to the infringer supported the conclusion that the lost market share was primarily lost to the infringer and not to the other competitors, because the other competitors were not in Walmart. Only Pylon was in Walmart. And as I explained before, we lost Walmart to the infringer also caused the loss of the access to the other mass market retailers. And there also was testimony that the price erosion could be traced to Pylon's competition and not to competition by the other suppliers of similar products. And I'll talk about the strength or weakness of that evidence for a minute. So at this point, I want to talk a bit about the second prong, which is the infringer's inability to satisfy the judgment. Pre-eBay, post-eBay, that has always been a significant factor in the court's analysis on injunctive relief. Because you could have a situation in which a money judgment might bring the patentee close to compensation. But if there's a high likelihood that that money will never be paid, then the court has to pay attention to that. The evidence in this case, however, has me really concerned, because it was pretty, in my opinion, and others in the room who are familiar with this case may disagree with me, but in my opinion, what this evidence said was not that Pylon was on the brink of bankruptcy, but rather that Pylon had a completely average risk. of going bankrupt. And that was enough for the court to say that's a reasonable likelihood that the infringer will be unable to satisfy the judgment. What really happened here, I think, is that Pylon, for whatever reason, did not carry its burden of adducing its own evidence in support of its financial health, and instead wanted to rely purely on argument of counsel, and the Federal Circuit was not satisfied with that. But this has me concerned, because if all you have to prove is that the defendant has a merely average risk of bankruptcy, then that's really not much of a hurdle, is it? So that's just something to watch, I think, to see how this case is applied by trial courts on the prong of inability to satisfy the judgment. So another case I want to talk to you about real briefly, and I want to make sure that we give Frank and Ron plenty more time. This Edwards Life Sciences versus Corval case, which was just decided a couple of weeks ago, 2 weeks ago. I like to call this one the "We're Moving to Mexico" case, because the defendant tried to fight off the injunction by saying, listen, the only reason why we're infringing at all is because we chose to manufacture in California. If we manufacture in Mexico, then there's no infringement. So basically, federal judge in California, you have your choice. You can keep us here in California manufacturing this product, or you can issue an injunction and send us packing to Mexico. So the trial judge says, gee, I don't know, I guess maybe if the injunction really wouldn't be effective anyway, why bother entering it? Enter the Federal Circuit. Well, they weren't happy at all with that analysis. So this is the rule now in the Federal Circuit. Absent adverse equitable considerations, the winner of a judgment of validity and infringement may normally expect to regain that exclusivity that was lost with the infringement. Well, man alive, that sounds a lot like what the Eastern District of Virginia said in the eBay case. Absent exceptional circumstances, permanent injunctions will be granted upon proof of infringement and invalidity. So, and Judge Prost is really concerned about that. So where this is going, I don't know. Very fresh case. I'm sure there's going to be an attempt to take this one up to the Supreme Court. We'll see where that goes. Some of the adverse equitable considerations would include if the patentee in fact is not suffering any competitive injury, the competitive injury is being suffered by the patentee's licensee. If there's some sort of overriding public interest in continuing to have the product available and the patentee is not providing it to the market, or maybe if the patent is not being practiced by the owner based on the eBay concurrence and some dicta in Bosch. So I'm going to skip over the details there, because I just want to get back to these lessons learned from these two cases, which are two-supplier market, you got a really strong chance at sustaining the proof of irreparable harm. Multi-supplier market, not impossible, as long as you've got proof linking the infringer to your harms and weeding out the other infringers, you got a fighting chance. And inability to satisfy the judgment's a pretty low bar right now. Lesson for the infringer, especially from the Pylon case, don't respond with just pure attorney argument or that little gimmicky argument that says, well, I'm just going to take my ball and go home, right? The Federal Circuit is looking for you to bring economic evidence just like the infringer brought. And I know that there are cost considerations for defendants. Adding an economic expert to your defense team is a significant expense. If you choose not to do that, you're probably going to need to tell your client that it's going to be real hard to overcome a prima facie case that of causation and of inability to satisfy a judgment.
Hi there, this is Rachel Erdman, Podcasting Committee of the Intellectual Property Section of the State Bar of Georgia. Welcome to Part 3 of our podcast, Intellectual Property, Injunctions After eBay. This was presented by Frank G. Smith III from Alston Bird. This podcast was originally recorded at the State Bar of Georgia Conference Center on November 28, 2012.
If I stay up here, can everybody still hear me? Because I want to talk a little bit with Ron and Ann as well as with you folks. Is that okay? Yes. All right, I don't hear any too stringent opposition to that. Before I get into what I was going to talk about, I'd like to follow up a couple of questions with Ann.
Sure.
You said something there at the end that I thought was very instructive. You talked about the economic expert. Now, traditionally in patent cases, there are two different types of damages experts. The accountant on the one hand, the economist on the other. I think when we're in this realm, it seems to me, based on what you've told us, we're clearly talking about the economist as opposed to the accountant. Is that right?
I think so, because you need someone who can describe the market circumstances. This is not just a balance sheet analysis of lost profits, which could be done by a CPA or other experienced business analyst. You need an economist. These cases are a lot more similar to antitrust cases than they are to a lost profits case, really, in my opinion.
And if we could go back one slide to the lessons learned.
Sure.
Because I think that's probably as an important a slide as in the entire deck. And there are a few other things that both Ann and Ron said that I think we might want to add to this. Does the patentee practice the patent? I mean, if you're a non-practicing entity, or if you're an individual, or perhaps a university, your chances of getting an injunction are going to be a lot lower than if you're someone who's out there actively practicing the patent and selling the product or the method or whatever it happens to be that's the subject of the patent. She's got the point up here about direct competitors. Also pay attention to whether the patentee has a policy with regard to licensing its patents generally, and in particular the patent in suit. If the patentee has licensed the patent in suit to several other companies, the odds that it's going to be able to get an injunction go down dramatically. On the other hand, if the patentee has a policy of not licensing its patents generally, and this patent in particular, the odds, I think, are going to go up significantly.
Or I will throw in one other thing, or you better have a really good reason why you're willing to license it to A, B, and C, but not D. And again, that rolls back into the market analysis and the economist expert analysis.
So anyway, that was just kind of stuff I wanted to follow up on the points that they had made. When we had this wonderful opportunity for either an inexpensive or free lunch, depending upon how you look at it, I sat down with Matt Howell and Pam Counsel, who are two of the younger lawyers in the firm, who've worked with me a good bit over the last couple. I had the unfortunate pleasure of working with me over the last couple of years. And we tried to come up with a list of things to think about of what do you do once you get an injunction. And you think that most big law firms, as well, they're on the defense side most of the time. Well, as luck would have it, for the last 2 years, we've been almost exclusively on the plaintiff side, litigating the Mariel cases in the Middle District of Georgia, and also some other litigation up in the Western District of Wisconsin, and a trademark case in the Southern District of New York. And what Matt and Pam and I came up with was essentially those 4 points of things to think about once you get an injunction. And clearly, once you have an injunction, you can enforce it against the party that's been enjoined. But it's not limited to that. If the enjoined party has an identity of interest with others, perhaps a wholly owned subsidiary, you can have that entity probably subject to the injunction. There's also the old acting in concert and aiding and abetting concept, such that if someone else is working hand in glove with the enjoined party and has actual knowledge of the injunction, then that person is also subject, or entity is subject to the injunction. And that's what we used in the Marielle litigation, where we were successful in taking an injunction that we had entered against one company and enforcing it against several others who were acting in concert with the enjoined party. There's another footnote to all of that, which is if you get an injunction and you want to enforce it against perhaps persons other than the enjoined parties, make sure you get the injunction publicized, because it's a requirement that the aider and abetter have actual knowledge of the injunction if you're going to enforce it against the aider and abetter. Anyway, we've got a handout, and the first page or so describes who can be enjoined and lays out both the Federal Rule of Civil Procedure and the case law some of the case law that addresses those points. Question then becomes, okay, so you got your injunction, you've targeted who you're going to enjoin, but what do you enjoin? And the patent case in this area is TiVo. It came out from the Fed Circuit in what's that, 2010?
2011, maybe.
2011. And it says that there's essentially a two-part test. And you love the way courts have to say things. It says the newly accused product is no more than colorably different than the previously adjudicated to be infringing product. Well, why didn't they just come out and say it has to be almost the same thing as, or very similar to, instead of coming up with these double negatives and words that people don't really understand, even lawyers. But, you know, that's the Federal Circuit for you, so they write things as they choose. And then once you determine that the product, the new product that you want to have the injunction enforced against is very similar to the product that was actually enjoined, you have to do an analysis at some level to confirm that the new product also infringes the patent. Because it's not inconceivable that the new product, while very similar to the enjoined product, would not necessarily infringe the patent.
Right, because everybody's looking for that successful design around, right?
Yeah.
Among other things.
So they come close. And
right.
So it's got to be very similar to the enjoined product and nevertheless be shown to infringe the patent that's in suit. There are a couple of things you don't get to do there are a couple of things that the accused infringer doesn't get to do on the when you pursue the contempt remedy for violating the injunction. You don't get to challenge the initial ruling. It stands, because the issue is not whether the ruling was right or wrong. The issue is, are you in violation of the ruling? And you don't get to collaterally attack the validity of the patent. So the contempt proceeding is a very powerful remedy. And that's how you enforce it. You enforce it through a contempt proceeding. Matt describes that at pages 3 and so forth on the little handout that we
Something
have.
with which he has a little familiarity.
And it's done, as I say, through a civil contempt proceeding. Now, there's a lot of real interesting case law there, because what the cases say is that the remedy has to be compensatory, not punitive. And then the cases go on in many instances to permit enhanced damages, which you would certainly think of as punitive as opposed to compensatory, but nevertheless there are cases which say that that is compensatory. It permits damages in excess of the plaintiff's lost profits, perhaps under a disgorgement theory. So when it says it's got to be compensatory and not punitive, the courts, again, really don't necessarily mean what they say. Now, there are cases that go the other way. They say it's got to be strictly limited to what the patentee actually lost when the other party violated the injunction. But there are lots of cases that, in my mind at least, clearly do permit more than simply compensation. And if you step back from it a little bit, you got to kind of wonder, well, why can't we be punitive toward the person that's violated the injunction? I mean, after all, they have violated a court order. To obtain the contempt, you have to prove by clear and convincing evidence that they not only violated the court order, but they knew about the court order, and pretty much that they knew that they were violating it. So why not impose some sort of penalty on someone who's done that sort of thing? But nevertheless, the courts say, no, it has to be strictly compensatory because it's a civil.
I have a question when you have a stopping point.
I have a stopping point.
Okay, and maybe I ought to direct it to Matt, I'm not sure. But, but on your point about why shouldn't you be able to have some sort of punitive remedy against a person who's violating the court order, are there cases that talk about more punitive type sanctions under other authority besides civil contempt authority, court's inherent authority, kind of some of the sanctions hooks that you get for parties for violating, discovery rules or things like that? Is there anything out there in that regard?
I didn't see much. It's usually they just look strictly civil versus criminal, and if it's criminal or punitive, then
right.
It's civil, it's not, but it can be other than that. The last thing we looked at was the extraterritorial effect of an injunction. And it's pretty clear that under a direct infringement theory that the activity has to take place in the United States under the patent statute. That's not necessarily so, particularly with an indirect inducement theory. What we had happen in the Marielle's situation was the originally enjoined party was in India. It was sending product into the United States. We got that enjoined. Several years passed, and infringing product showed up in the United States, and we traced it back to the company in India that had been enjoined a couple of years earlier. They said, no, not us. We're selling it to a company in Dubai. The company in Dubai is selling it to another company in Dubai, and the second company in Dubai is selling it to the company in the United States that had commissioned the company back in India to make it in the second place. And the court pretty much saw through all of that on an inducement theory. And in fact, when the original contempt order was heard by the Federal Circuit, one of the Federal Circuit judges at oral argument analogized that sort of conduct to money laundering. Instead of money laundering, you're just laundering the product by running it through a couple of dummy entities in Dubai.
Not a great day for the defense.
But anyway, those are the things that I wanted to go over, and if anybody's got any questions, Matt will be happy to answer them.
Actually, I'd like to go back to more.
Hello, this is Rachel Erdman, Podcasting Committee of the Intellectual Property Section of the State Bar of Georgia. Welcome to Part 4 of our podcast, Questions and Answers, Part 1 of the Intellectual Property Injunctions After eBay. This podcast was originally recorded at the State Bar of Georgia Conference Center on November 28, 2012.
Actually, I'd like to go back to a more general question in terms of the injunction at the front end and ask the panel. This is kind of a scenario where your company, your client has come up with an innovation. He's invested in building the market for it. The other competitors are sitting around watching to see how it goes. They try and engineer around it for a year or two, can't do it. You've got your patent issued, and suddenly they jump on the market and say, I can't compete legally, I'm going to infringe. Okay, you want to go after them as quickly as possible, shut that down before they do the harm to you, and before they get so invested in it that they have to fight tooth and nail to save their investment. What kind of analysis can you do at that early stage before the competition has gotten really intense to try and get this cut off with an injunction? I mean, all of the harm elements and the lost profits and the market erosion and all that stuff hasn't happened yet.
Right.
But it's foreseeable.
I think I understand your question. So, first of all, the most recent cases in front of the Federal Circuit just haven't involved that fact pattern. But one of the useful things that's in these cases is a reaffirmance of the old jurisprudence. So you can go back to some pre-eBay cases that are more consistent with that fact pattern, and as long as you're not relying on a presumption, but instead an analysis of factors, you might find some help in the older jurisprudence.
Oh, I'm sorry.
And then the other thing I wanted to address is, of course, if you can show investment in actually trying to bring a product to market while at the same time pursuing the issuance of the patent, that's going to put you in a position different from the classic non-practicing entity that Justice Kennedy was talking about, and that is discussed in the dicta in the Bosch versus Pylon case from last year. The other thing, this brings an opening to talk about yesterday's fresh injunction case from the Federal Circuit. I didn't feature it in the discussion because it's not an irreparable harm case, but it is a preliminary injunction case. And this is the case of Revision Military, Inc. versus Balboa Manufacturing Company. And this case involves the question of whether on a preliminary injunction there can be an increased standard of proof for likelihood of success on the merits. And the trial court applied a Second Circuit rule that said, for preliminary injunction, we're only going to grant it if there is clear and substantial proof of likelihood of success on the merits. And the Federal Circuit said, no way. The standard for likelihood of success on the merits is more likely than not and nothing more. So that's something helpful for an entity in in that situation.
Kevin, the two things I would do are to go to get two really good witnesses. One from in the company to talk probably in marketing and probably as senior as you can get, who's still got hands-on knowledge of what goes on in the marketplace, and get that person to talk about how the market works. And then I'd get a really good economist to take that executive's lay testimony and spin's not the right word, but convert it into an economic analysis of what's going to happen in the marketplace and why that would create irreparable injury, erosion, price erosion, erosion of market share, and all the other things that are indicia of the type of injury that supports an injunction.
And along those lines, one of the things the law, area where the law has not changed is you can still get injunctive relief based on the threat of irreparable injury. And so we shouldn't get too, sometimes we ignore that. And so threatened irreparable harm, the practical question is, how do you prove that threat? And along the lines of the economist expert Frank was talking about, it may be a market where you've got a significant first mover advantage, and if you don't have the opportunity based on your patent right to have that first mover advantage, then you lose it forever. Kind of traditional economist analysis. And the other thought is, if you've got analogous situations with your products or other products in the same market, would be the things I would get to tie back to evidence of that threat. And
that first mover advantage is discussed in the Edwards Life Sciences case. And interestingly enough, the trial court said, well, you're right, you lost the first mover advantage, but it's already gone, so I can't worry about that now.
Which is all the more reason to get in a hurry, like you're talking.
Right.
We're going to back out of patents for a minute and talk about other intellectual property cases, a little bit about copyrights, and then conclude more about trademarks. And the law at least how eBay is applied in the copyright context has been more consistent, certainly, than the trademark context, because the Supreme Court and eBay made analogies to the copyright cases, and so for the most part, courts have not seen a basis to deviate from eBay in copyright cases. And I put up these, all with the exception of the Seventh Circuit case recently. The other three cases are discussed in detail in our article that's the handout. People might recognize the Salinger case as the unauthorized Catcher in the Rye sequel, where an injunction, I believe, was initially denied or initially granted, and then the Second Circuit, in no uncertain terms, basically says eBay applies in the copyright context, and we see no reason why it doesn't apply in all intellectual property contexts. The law is pretty clear on that, although back to the economic analysis, which doesn't come up as often in copyright cases, at least in my experience, as it does in patent cases. If you're dealing with a copyright in a product that is licensed, any thoughts on where the irreparable harm analysis might come down if you've got somebody who's licensing the product? Come on, Mark.
Well, if someone's continuing to use the copyrighted manner after the license is terminated, I would think you probably have a pretty good argument for irreparable harm.
Who's willing to take the argument for no irreparable harm and you're stuck with your damages?
Me.
Remedy. All right.
You'd already put a price on it, and it seems to me that if you put a price on it, that's your price. And using the copyright with copyrighted work without permission requires compensation. But unless you've got one of those, inability to satisfy the judgment situations, I think you're kind of stuck.
What about a situation where you put a price on it, but the price was based upon exclusivity?
Well, then that would be different.
Yeah.
Because then you're more in the patent context where the idea of it is someone has the right to exclude others, right? Either it's you as the owner of the copyright or it's your licensing.
Why would that be limited to patent as opposed to copyright or trademark?
As long as there's an exclusivity component, I guess is what I'm pointing out.
If you're interfering with someone's exclusive license rights.
Right. If the licensed right is an exclusive one for either a trademark or a copyright, then the licensee's right there is much more analogous to the right of a patent owner, where the right is defined as the right to exclude others. But if you've been licensing your copyright to 10 people, and then an 11th shows up using it without permission, I think you've probably set your price.
Well, once again, I've been involved in licenses where there was an exclusivity with respect to a specific field, or alternatively with respect to a specific geographic area. So I don't think it comes down to you've licensed others and therefore you've set a price on it. You may have set a price on a specific issue that is then being contravened by the infringer. And also, with respect to copyrights, Copyright Act also provides an exclusivity. It specifically sets forth exclusivities.
Right, the exclusive rights of
that belong to the copyright holder. So I don't see where the patent issue comes up at all.
Don't see, I'm sorry, where the patent issue?
The comparison of this is like a patent matter. Copyright is independent.
Well, I think from what I've seen in the copyright cases, the focus is if your focus is on monetizing the right through licensing, and there aren't other considerations, I think, like Ann was talking about, you license it exclusively to someone, you may have an obligation to enforce the right to protect your exclusive licensee, or you may that may impair your right to license it in other fields or in other geographic areas or something like that in the future. There may be those considerations that are different than just, I want to license my product and I want to sell as many copies as I can. I think that's generally the differentiation that Ann is making. Was there another question or comment back? And I guess the last thing I'd say on copyright is that most of the cases that you see that involve creative or creative works where there's a reputational component to the author or the creator generally are treated a little bit differently and more often refined irreparable harm.
This is Rachel Erdman, Podcasting Committee of the Intellectual Property Section of the State Bar of Georgia. This is the last segment of our Intellectual Property Injunctions After eBay podcast. This podcast was originally recorded at the State Bar of Georgia Conference Center on November 28th, 2012.
But trademark is the area where there's really been the most uncertainty in the application and whether a presumption should still apply. And I think courts recognize a tension between the pretty clear holding of eBay that the traditional four-factor test applies, and at least in the patent context, you shouldn't apply this general rule or presumption. Contrast that with the nature of the harm that most of us, going back to Trademark 101, recognize from any infringement. And so I think the question is that courts have grappled with and commentators have grappled with is, are trademark cases just different based on the nature of the rights involved? Before I ramble on, is anybody willing to make the argument that trademark cases are different and why?
Sure. Trademark, specifically by definition, indicates the origin of the goods. And if you're providing some other origin, then you're outside the scope of the trademark right.
Anybody willing to take the other side and argue why, that's not enough of a difference to say a presumption should still apply?
Well, I won't take the other side, but I'll add something to that as far as why I think trademark cases are different. Because as you stated earlier, the harm from an infringement, if you can show likelihood of confusion of the public, is inherently an intangible harm to the goodwill and the reputation of the mark and of the mark holder.
What if you can't show actual confusion?
Pardon?
What if you are unable to show actual confusion? Because your survey results don't support it, or your client's not rich enough to afford a survey?
Well, if you can't prove a likelihood of confusion, then you're not going to be able to prove likelihood of success, so you're not going to get an injunction anyway. And you don't have to prove actual confusion to prove a likelihood of confusion. Now, certainly if you had proof of actual confusion, that would make your argument even stronger.
What about back to the ever-handy expert witness? Don't expert witnesses value goodwill all the time in business cases? Well, why is that any different than than a value of the business where you're putting a value on goodwill? I think that's a good question. Courts seem to think so because they're just unwilling to give up that presumption. But the question is, should the presumption still apply? And this kind of covers a lot of the things that folks just commented on, back to the fundamental purpose or nature of a trademark that identifies source. And maybe most important, it's an indication of quality or reputation of products or services. And courts will generally, the last several bullet points there are the things that most cases talk about in order to justify either the rationale for the presumption, or if they say we're not going to apply a presumption, they just kind of recite these factors generally. There are not many cases where parties actually go to great lengths to try to present a lot of evidence of these things. Courts are generally more willing than maybe in Anne's patent case earlier that she talked about to accept the buzzwords rather than actual proof for that. And I think that's something that's interesting. This is probably violates the fundamental law of PowerPoints with too much text on it, and it's in the article, so you don't have to look at it. But the leading 11th Circuit case is still this 2008 case called North American Medical, and it is interesting because it says, well, yes, we recognize that eBay applies, and we're going to reverse the district court and send it back to apply eBay, but we're not going to rule on the question of whether irreparable harm is a natural consequence of trademark infringement, or the quote from the court, whether such a presumption is the equivalent of the categorical rules rejected by the court in eBay. And I can just imagine the district judge who had this case seeing this opinion, coming back and going, well, that's great, thanks a lot, for that insightful analysis. I hope there are no 11th Circuit judges behind me.
Do we know what happened? After remand?
I don't. That's probably a good, interesting thing to look at.
Who was the 11th Circuit judge who wrote that?
Good question. I can't disparage anybody because I have no intent. I don't know who wrote that. But the interesting thing to me is that if you look at more recent cases, in 3 years after, you've got district courts in different places in the 11th Circuit going different ways. You've got courts that say no presumption, and I think that's a Judge Carnes case from the Northern District, the Internet Shops case. And then you've got probably the best case, at least that we found, in terms of analyzing the way different courts have gone back and forth on the issue since eBay, is the Sylvan Learning case. That court did what most judges do now, in my experience, is to say, we either think a presumption does or doesn't apply. If they say we think the presumption does apply, they nonetheless say, but we're going to go on to analyze it without the presumption to try to, since they can't guess what the 11th Circuit is going to do. So, but as a practical matter in those cases, and I'd be curious if anybody in the audience has any different experience, I just don't see a lot of actual presentation and analysis of evidence. It's mostly, well, we have a trademark and it protects our reputation.
How much of the analysis on this are you think is rationale and how much is rationalization? I mean, is this a result-oriented analysis, or is it a principled analysis?
I think it's a principled analysis for the most part, because I think the analysis is we just think trademarks are different and they protect different interests. And if you look at, for example, the McCarthy treatise, he takes a very strong, that treatise takes a very strong position that the presumption of irreparable harm in a trademark case is in no way inconsistent with the Supreme Court's eBay decision or the application of the traditional injunctive relief factors. The nature of the harm in trademark cases is just different.
In my experience, has been where you would have 2 sentences before that they'll, after spending 10 pages on the likelihood of confusion analysis,
right,
you spend 2 sentences on irreparable harm. Now you spend a paragraph, and you say, you don't say there's a presumption because there's trademark infringement. You say because there's likelihood of confusion, there's going to be irreparable harm.
These harms necessarily follow.
Right, exactly.
From that, which to me is a presumption, but it's not stated.
Necessarily follow. So there's an presumed to follow.
Right.
So this is just some information from the article. The other circuit, the 11th Circuit is not the only one on the fence. Other circuits have not really been very definitive. The most definitive guidance is for those of you who practice occasionally in the 2nd Circuit, back to that Salinger case. The definitive language that we see no reason why eBay doesn't apply, no presumption apply any IP case. District courts in the 2nd Circuit pretty uniformly declined to apply the presumption. So at the end of the day, the question is, does it really make any difference? And this is where I think, I'll step aside and open it up to the rest of our panel. I think in the patent area, I think it has made a significant difference.
The most significant difference being what's already been discussed. If the patentee is a non-practicing entity, it's going to be, and not a non-practicing entity who just hasn't had the chance to practice yet, as Kevin posited to us earlier today, but an entity that owns the patents for purposes of licensing them. The eBay makes it pretty clear you cannot use the threat of injunction to extort rents for your patents. So in that sense, that's the easy case for saying eBay has made a difference in the patent realm.
Yeah, I think there's another interesting area too, and it's reflected in a recent, about a month or month and a half ago, Federal Circuit opinion in the ongoing Apple-Samsung smartphone wars, where the Federal Circuit reversed an injunction because of the number of component patents that made up the smartphone, and that there was not sufficient proof that the particular infringement was a real driver of consumer demand for the products. You can't really say I've lost market share or whatever. I think that, just back to what Frank and Ann were talking about earlier, the depth of economic analysis that you now need and marketing analysis that you now need in a lot of these cases.
So you have a shot at getting your injunction without the presumption, but you need to be ready to prove a lot more about the market and its effect on, and the infringer's effect on your company.
And then in the trademark area, at least my observation is I don't think it has made a big difference in most cases for a lot of the reasons we were talking about a few minutes ago, and I made reference to the McCarthy treatise quote. I think the biggest impact, and I'd be curious to y'all's thoughts or anybody from the audience's experience, the biggest impact is it just gives you the opportunity to focus the court more on this as a factor, and if you're defending an injunction, it's just another battleground that may be a little bit more prominent than it was before. If you're pursuing an injunction, it's something that you can't get away with just a paragraph in your brief and not worrying about the evidence that you present.
A question that one thing that eBay was seen to do is be a driver of sending litigants to the ITC, where you don't have to deal with all this, you just get your injunction, get your exclusion. Do you think that as this all shakes out in the courts that clients will start to say, why am I spending so much money going after parallel actions in ITC and district court, and just focus on the ways that they can go at this in the district court and focus only on that level?
Have an opinion about that, Frank?
The ITC is just so different.
I'm with you. There are a lot of good reasons to go there that don't.
Well, there are a lot of good reasons to go there, and there are a lot of good reasons not to go there. And they tend to be, if you say what the good reason is, that's also the bad reason. The speed, the cost, the fact that it's only an injunction. I mean, all those are pluses and minuses depending upon what the client's goals are and financial resources. And it is just, having been there, though not as much as some people in my firm, it is just a different beast, the ITC, from district court litigation.
And you also have to show that there's a U.S. industry that's impacted.
You've got to satisfy
and
U.S.
the defendant has to be important.
You've got to satisfy public interest. There are all kinds of, on the other hand, you don't have to prove, you're not allowed to prove damages.
Right.
So that takes a big chunk of the case and pushes it off to one side. One interesting issue I think you're going to see is the ITC grappling with, is the plaintiff here simply for the purpose of getting an injunction and then using that injunction to leverage a dollar settlement? I think that's something they're going to be grappling with.
Anybody else have any thoughts, questions, issues? Well, thanks very much. We appreciate everybody's attention.
Thank you all. Well thought out. You guys actually worked as a team. So thank you, panel. I also want to thank, probably admonish me for doing this, but recognize Phil Burris here, who's the chair of the IP section. Man works very hard. The IP section out. And you see chips in doing anything necessary, including running the soundboard. So
I think that's why he became chair, so he could run the soundboard.
All right, so hopefully see everyone December 5th. You can sign up at georgiagabar.org. All right, we're adjourned. Thank you.
Thanks, David. I hope so.